Welcome to today's program titled Guidance on Paid Family Leave Laws, Part 8, Comparing State PFML Laws and Mid-Year 2023 Legislative Updates. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thanks so much, Kate. Hi, everyone. Good afternoon. Good morning. Thank you so much for joining us today for Part 8 of our Paid Family Leave Laws webinar series. We're so excited to be here with you today. Joining me for today's presentation are my colleagues and good friends, Marlon Duro-Martinez, Christina Duslack, and Renata Walker. I'm Josh Seidman, co-lead of our firm's Leaves of Absence Management and Accommodations team. For today's presentation, again, the 8th of our Paid Family Leave webinar series, we're going to be covering two sort of big important topics with some details and nuances within each of them. As you'll see on the next slide, the first big topic is going to be giving you a lay of the land of paid family medical leave laws and paid family leave laws in terms of where things stand today and what most notably has happened during the first half of 2023 in Minnesota and Maryland. We're then going to turn our attention to number 3 on this list, which is a paid family leave, paid family medical comparison. It's a really important topic. We're really excited to bring that piece to y'all in particular. We're going to be looking at each of the existing 12 states plus Washington, D.C. PFL and PFML programs and comparing them across 10 core substantive topics. Really good information for those of you with multi-state and nationwide operations. We'll then wrap up with some final thoughts, and if there's time at the end, taking some questions from folks. As you'll see on the next slide, we're going to jump right in with our terminology and historical review. So we'll go one more slide in and get us started. So the paid family leave, unpaid family medical leave landscape includes 4 key groups of this type of law. You have your unpaid family medical leave laws, or FML laws. You have your disability insurance laws, or SDI laws. You have your paid family leave laws, or PFL laws. And you have your paid family and medical leave laws, or PFML laws. There are a lot of commonalities and overlaps between these laws, but also some really important differences. So let's go over a few of them. For starters, the unpaid FML laws are unpaid. The second, third, and fourth groups on this slide all include some type of wage replacement component. The unpaid FML laws also include, generally speaking, job protection, a right to reinstatement following the leave period. So while some of these other laws do include the SDI, PFL, and PFML laws, that is, do include both wage replacement and job protection, right, a right to reinstatement, some of them do not. Some of them only include a wage replacement component, not the right to reinstatement job protection component. In terms of covered absences and qualifying reasons to use the benefits, the unpaid FML laws, PFL, and PFML laws all generally cover bonding with a new child following birth, adoption, or foster care placement. They'll generally include care of a family member with a serious health condition. But unlike the PFML, SDI, and FML laws, the PFL laws do not cover absences for the employee's own serious health condition. right? And that's because the 4 states that have PFL laws, right, the paid family leave laws, those jurisdictions also have a corresponding SDI law that fills that gap, that does provide wage replacement for the employee's absences related to their own disability that is not related to their job, right? Their own illness or accident, not work related. So those are some of the big differences. And you might ask, well, why do we have PFL laws that cover bonding, cover family member serious health, but don't cover employee-owned serious health condition, whereas the PFML laws do cover those bonding and family member related absences plus employee-owned serious health condition? The reason is because the SDI programs in those states that have now PFL laws predated the PFL laws by several decades. So the PFL there was an add-on, whereas in the PFL jurisdiction, there was no pre-existing SDI program. Next slide, please. A few more terms just to set the stage. Today, we are not talking about paid sick leave laws or PSL laws. They can also be known as paid sick and safe time or mandatory PTO laws. Those are laws that are, while a lot of folks at a high level sort of conflate them with PFL and PFML, there are a lot of differences between them. Paid sick leave laws don't generally involve insurance components, right? They don't generally involve a state program like PFL and PFML laws do. They also generally provide 100% wage replacement for employees, whereas there are weekly caps under the PFL and PFML laws. And the paid sick leave laws generally cover shorter term absences, absences where you're feeling a little sick, you have a tickle in your throat, you have the flu, you need to go for your annual physical. Whereas the PFL and PFML programs cover more serious, more significant life events like bonding, like having a serious health condition. The second bullet point here, there are and have been, but are very few left today. There were COVID paid leave laws, supplemental paid sick, emergency paid sick, which are SPL and ESPL, as well as more permanent, not specific to COVID public health emergency leave laws that exist in a few places. We're not going to be covering those today either, but as a sort of a quick note, on Tuesday of next week, on June 20th, our team is going to be presenting the next segment of our separate paid sick leave webinar series, where we will be covering all the latest happenings with paid sick leave, with COVID paid leave and public health emergency leave. So if you're a multi-state nationwide employer, it's another webinar that's worth your time. Then we also have company provided benefits, short-term disability, long-term disability, paid parental leave, STD, LTD, and PPL. The big note there is that it's important for employers who have those company provided programs and benefits being offered to employees to make sure that they understand how to coordinate those programs with applicable statutory unpaid FML, SDI, PFL, and PFML programs, because it isn't always as simple as just saying they run concurrently. We're going to offset the pay. In many jurisdictions, the PFL and PFML programs require the employer to take a careful look at how those benefits are going to be coordinated, and in some places prohibit the concurrent use and require stacking of benefits. Next slide, please. So here's what the landscape for paid family medical leave laws looks like today. We have 5 states with SDI laws: California, Hawaii, New Jersey, New York, Rhode Island. 4 of those states, California, New Jersey, New York, and Rhode Island, also have paid family leave programs. Those are 4 of the 12 states plus DC that either have a PFL or PFML law that's been enacted. That last bullet point shows the 9 jurisdictions that have a paid family medical leave program. 4 of them are currently providing benefits to employees. Those are Connecticut, Washington, D.C., Massachusetts, and Washington State. The other 5 programs come online between this September, starting with Oregon, all the way through 2026. Next slide, please. There are a few twists that have come up recently in the paid family medical leave world. We're not going to be focused too much on these today. They won't be part of our comparison section of the presentation, but worth noting, there are 2 states, New Hampshire and Vermont, that have recently instituted voluntary paid family medical leave programs where employers can opt in to those programs. Again, they're not mandatory PFML programs like we spoke about on the last slide. The New Hampshire program went online earlier this year. The Vermont program goes online for private employers in about 2 years. You also then have Virginia, which is an added little wrinkle in the space. The Virginia legislature recently added family leave insurance as a class of insurance that insurance companies can now develop and market as a class of insurance. So another added wrinkle in the space that isn't a mandatory or voluntary program. Are these going to be signs of where PFML is heading in the future at a broader scope than just these 3 states? Or is it sort of stepping stones in these states to a mandatory program? And we'll see what happens. But again, wrinkles in the landscape that is worth being aware of. Next slide, please. We're now going to spend just a couple of minutes talking about some of the latest developments from this current 2023 legislative session involving paid family medical leave laws, most notably in Minnesota and Maryland. Next slide, please. Starting with Minnesota, which is sort of the big ticket item in terms of new developments. The Minnesota program goes into effect, and by that I mean providing benefits to employees starting on January 1st of 2026, with a number of intermediate sort of components going online in the months and years prior to that. The maximum length of benefits is a little bit messy, right? But here's the way that I've tried to think of it since this law was enacted last month to help make some sense. We'll talk about covered reasons on the next slide, but the covered reasons are very related to the maximum length of benefits. You have sort of these 2 groups. Group 1, medical-related absences, which the law defines as the employee's own serious health condition and those related absences. You have a second group, which are sort of family-related absences. And that's basically everything else that the law covers: bonding with a new child, family member's serious health, qualifying exigency, and so forth, with one little nuance that I'll mention on the next slide. What the law generally says is employees can get up to 12 weeks in either the medical bucket or the family bucket per year, and then up to 8 weeks in that same year from the either bucket, for a total of up to 20 weeks of time off of leave in the same benefit year. So that's how the maximum length of benefits works in Minnesota. Benefits can be obtained from the public program as run by the Minnesota Department of Employment and Economic Development, the DEED. There's also a private plan offering that we'll speak about in a little bit because it is a nuance as compared to how other state PFML private plan programs are set up. The covered employer threshold is incredibly low. Just having a single individual in covered employment in the state is enough to cover that employer. And employee eligibility is also a fairly low bar, especially compared to the FMLA. There are multiple eligibility components, including a financial eligibility test, as exists in a number of other state PFL and PFML programs. But again, a low bar, generally speaking, as compared to the FMLA. Seasonal workers are excluded from coverage under this law as well, as are independent contractors. Next slide, please. So here are the covered absences that I was starting to get to on the last slide. You have your serious health condition, the employee's own serious health condition related absence. You have, that is sort of the group 1, right, as I mentioned, right, for the 12-week sort of maximum in a year. Then the next 4 bullet points, qualifying exigency, safety leave, family care, and bonding, all fall into that second group, right, the other potential up to 12 weeks. Medical care related to pregnancy, which the law talks about as being prenatal care and time away from work for that reason, or incapacity due to pregnancy, recovery from childbirth, pregnancy, or related health conditions. It isn't really listed in either the medical or the family groups as far as that 12-week maximum goes for Group A or Group B. So we're waiting for some clarity from the state on that piece in terms of how many total weeks the medical care related to pregnancy component of this law will have when the benefits go live in 2026. Safety leave, worth a quick note, that is really taking a page out of the paid sick leave world and covering absences related to the employees or their family members' victim status due to things like domestic violence, sexual assault, or stalking. Family care covers family member's serious health condition as well as caring for a family member who's a member of the military. Next slide, please. Definition of family member is quite broad, covers parent, child, spouse, domestic partner, grandparent, grandchild, sibling, as well as any individual who has a relationship with the applicant where there would be an expectation that the applicant would care for that individual regardless of whether they live together. Minnesota's program also carries a right to reinstatement. That means the employee can be returned, must be returned, to the same position or an equivalent position following their leave and time off. With one caveat, the law does require that the employee be employed for at least 90 calendar days from their date of hire in order to have that right to reinstatement. The law provides for a partial wage replacement, as do pretty much all the other PFML laws. The range of the wage replacement goes from 55 to 90%, depending on a couple of factors, such as the employee's regular weekly pay, as well as the statewide average weekly wage. And then finally, in terms of how the program is going to be funded, it'll be funded through premium collections. The premiums are currently set at 0.7% of the taxable wages paid to each worker who is covered by this program. Now, that 0.7% is if the employer is following the public program for both the medical and the family, as I mentioned on the last couple of slides. However, a wrinkle in the private plan set up for Minnesota, employers are allowed to apply for and obtain a private plan for only medical or only family-related absences. And if that's the case, then the premiums would drop down to either 0.3 or 0.4% of the relevant taxable wages paid to the workers, not that 0.7%. So that's a wrinkle in terms of the premiums and how they're set up, and a wrinkle in how the private plan offerings are set up under this law. Next slide, please. Very related, the program is funded through a 50-50 split between employers and employees. Premiums are due to be remitted on a quarterly basis. Employers do have the option of covering the employee portion if they so choose. There are posting obligations. There are individual employee notice obligations, both for new hires as well as for existing employees 30 days before the premium collection sort of begins. There's also, taking another wrinkle out of the paid sick leave world, a requirement from this Minnesota PFML law that employers now have to add line items related to the PFML payroll deductions and premium collections for that specific individual to pay statements starting 1/1/26. And I should have mentioned that those posting and notice obligations begin in November of 2025. Next slide, please. So to round out Minnesota, there's a record-keeping obligation of up to 4 years to maintain relevant benefit records. There is also a private plan offering, as I mentioned, with some nuances and wrinkles. Employers can require that Minnesota PFML run concurrently with leave under the FMLA or the Minnesota Pregnancy and Parental Leave Act, assuming the employee is eligible for leave under those relevant laws. The employer cannot require that the employee exhaust either before or concurrently with Minnesota PFML their sick time, vacation time, or other PTO that is being provided to the worker. So that's the Minnesota law. At a high level, it continues a couple of trends that are favorable for employers, offering a private plan, the funding split between the worker and the company, but there are many components that make this a law that is leaning pro-employee. The 20 total weeks being a really high threshold, as Renata will talk about in a few minutes. The broad reasons for use in covered family members, as Christina will talk about in a few minutes, and continuing a trend of low eligibility, low employer coverage standards, as Marlon will talk about in a few minutes. Next slide, please. So to quickly round out my portion, we have some important pro-employer updates for the Maryland PFML program. Most notably, the employee contribution go-live date and when the benefits become available to employees go-live dates have both been pushed back a year, as you can see on this slide, with the benefits now becoming available 1/1/26, joining Delaware and Minnesota with that specific date. The coordination and benefits topic, this is one that we spend a lot of time on at Seyfarth, counseling our clients when they're dealing with these PFML laws and compliance with them. Needless to say, the Maryland updates are a positive development for employers, specifically because of that second sub-bullet point here, which now makes clear, which was not the case under the original statute, that there can be benefits that can run concurrently, and the employer can mandate that they run concurrently and be coordinated with the employer provided parental leave, short-term disability, things like that, and the Maryland PFML program. Finally, contributions are going to be split 50-50 between companies and the worker, just like with Minnesota. That was also unclear previously. So with that wraps up our overview of the nationwide landscape and the legislative developments that are most notable from the first half of this year. We're going to turn it over to Marlon to get us started with the PFL comparisons portion of the presentation.
Thanks very much, Josh. So as Josh said, now we're going to talk about paid family leave and paid family and medical leave laws only. rather than all the other laws that Josh talked about. So with that, we're going to start out with a poll on this next slide. We know these laws are confusing, so we want you to tell us what part of these laws you find the most confusing. So you'll see a poll question to your right. So just click the answer and hit submit. So do you find employee eligibility confusing? So whether employees are covered and eligible for benefits, including relating to telecommuting employees. Do you find qualifying absences and knowing which events are covered and which family members are covered confusing? Or do you find the length of benefits confusing? How long of leave can an employee take for a specific event? Do you find job protection versus wage replacement, whether the law requires one or both of these things, confusing? Do you find coordination with employer-provided benefits confusing? So there's all these different laws out there and all these different employer benefits. How do these all work together? Or do you just find all of these things and maybe some other things confusing, because we know these laws are very tricky. So just please submit an answer about what you find confusing. There's no right or wrong answer here. And we will close out that poll. So let's see the results here. So yeah, we got a decent mix of answers. People are confused about all of these things, and the biggest answer here is F, that all of the above, these are all confusing. And we know that, and we hope that in the next few slides, we're gonna make these things a little bit better to understand. So with that, we'll move on to our next slide. So again, we had people who were confused about all different kinds of these things, and we're going to be talking about these today. These are not the only topics that PFL and PFML laws cover, but these are some of the top ones that we see. So today we're going to talk about employer coverage and employee eligibility, qualifying absences and covered family members, job protection, program administration and funding, length of benefits, amount of pay, and notice and posting. And with that, we'll get started with our first topic, which is employer coverage. So anytime that we deal with any kind of leave laws, the first thing we want to know is the employer covered under the law? Because if you're not a covered employer, then you don't have to worry about the law at all. So to figure that out, we look at the various standards of the PFML laws, which are different than the FMLA. We've been used to the FMLA standard, which is that in order to be covered, an employer has to have no less than 50 employees for at least 20 work weeks in the current or preceding year. And we're used to this because this has been the standard for 30 years. However, while the FMLA bar is not very high to meet, the bar under the PFML laws is significantly lower. In fact, most existing PFML laws apply to employers that have one or more employees in the relevant jurisdiction, even if the employer does not have a physical work site. So even if you have a single remote employee working in a jurisdiction, you could be covered. And this is the standard in a lot of the existing PFML laws, including in Connecticut, Massachusetts, Minnesota, Oregon, Rhode Island, and Washington State. There are some laws that have a little bit higher eligibility thresholds. So for example, Delaware applies to employers with 10 or more employees in the state in the last 12 months. But again, that's a much lower bar than the FMLA. And with that, we're going to now look at employee eligibility. So if we've determined that you're a covered employer under the law, then we have to think about whether your employees are eligible, because even if you are a covered employer but you don't have eligible employees, you don't have to worry about the law just yet until you have somebody who's eligible. Now, as you'll see, this slide is a lot more complicated than the last slide, and that's because the PFML laws vary so greatly when it comes to employee eligibility. And if you can believe it, these are just some of the criteria for eligibility. There are many more out there depending on the jurisdiction. So the top one we see, and there's 8 different jurisdictions that apply this, this eligibility criteria, is wage amount threshold. So although you might think, great, 8 states have this, this is going to be great, Well, it varies significantly what that wage threshold is jurisdiction by jurisdiction. So for example, we have California, which requires that employees have earned $300 within the base period. And what the base period means, and you see this word also in that box to the right on the slide, is that the employee has earned that amount in the first 4 of the last 5 completed calendar quarters before the employee has applied for leave. So California has $300. Then we have jurisdictions like Oregon, which require $1,000 in the base or alternative base period. So in California, like I said, base period meant the first 4 of the last 5 completed calendar quarters, whereas alternative base period, we're instead looking at the last 4 quarters of the last 5 completed quarters. In Oregon, it's $1,000. Then we go to Colorado, it goes up to $2,500 during the base period or the alternative base period. And then we have jurisdictions like New Jersey and Rhode Island where the amount is much higher. In New Jersey, the employee would have to earn $13,000 in the base year, and in Rhode Island, $14,700 in the base year. So as you can see, it varies from $300 to almost $15,000. Some other eligibility criteria that's common is the length of employment. We see Delaware and New York both fall in that bucket. So New York, the length varies depending on whether the employee is part-time, so works less than 20 hours in a week, in which case they have to have worked 175 days to be eligible, whereas for full-time employees, those who work more than 20 hours a week, the employee has to have worked for 26 consecutive work weeks, which is 6 months. Now, Delaware falls both in that length of employment bucket, requiring 12 months of employment, which is the same as the FMLA standard, but it also requires an hour or percentage of time worked because it requires employees to have worked for 1,250 hours in addition to working for 12 months in order to become eligible. And even within this hours bucket, the jurisdictions vary. So Delaware is at the 1,250 mark, whereas we have Maryland at much lower, 680 hours, and Washington sort of falling in the middle at 820 hours. And there are a number of other topics that create the eligibility criteria amongst these laws, including whether the employee has contributed to PFML or has submitted a claim for PFL benefits, or in California, if the employee has, if the employer requires the employee to use PTO, that they have actually used the PTO. And as you see, California appears in quite a few of these categories, and that's because California has all these different eligibility criteria that has to be met before the employee becomes eligible. California was the only jurisdiction to require lost wages because of an absence, but now Minnesota has joined it in that category as well. And then Delaware has this different eligibility criteria than most laws, requiring that the employee meet the law's administrative requirements. What that exactly is unclear right now since this law is fairly new, but hopefully we will know more about that as we get closer to the law's effective date. And, you know, as you see, there's another box to the right with some additional kind of criteria for eligibility. So the former employee coverage, as well as the base period and alternative base period, which we talked about, as well as having a nexus to the state, which we will talk about in a bit. But one thing to keep in mind is that even if an employee meets the eligibility criteria, you have to make sure that the law doesn't have any disqualification criteria because, for example, in Minnesota, an employee could be disqualified if they have outstanding overpayment of PFML benefits due to misrepresentation, and a number of jurisdictions have disqualifying criteria as well, so make sure you pay attention to that. So with that, we're going to look over at the next slide, talking about telecommuters. So, you know, now with the COVID aftermath, there's even more employees who work remotely or work remotely part of the time, which makes it difficult to determine which law would apply to these employees. So typically, if an employee is working in one location only, whether that's 100% from home or 100% from the office, it's fairly easy to tell which law applies. But where it gets complicated is when you have employees who work from home a few days and in the office in a different state for a few days. And the answer is that it depends. So we would have to look at the specific jurisdictions that are triggered. We'd have to review the specific laws that are triggered. We'd have to look at the percentage, see how much time an employee is working in the office versus at home to figure it out. But what a lot of states do is they look at the place where the employee is subject to unemployment insurance tax. And based on that, you could tell which law applies. So in Connecticut, I'm just going to give you a couple of examples here. In Connecticut, if the employee is not subject to the state's unemployment insurance obligations, then the state looks at where the services are localized, or if it's not localized anywhere, where the base of operations is. And if it's not localized anywhere and there's no base of operations, they look at where the employee is receiving direction and control. And if none of that applies here, then the state will look at where employees reside. And if we look over at the next slide, we'll see that New York has a similar thing where they look at where the service is localized, where the base of operations is, where the service is directed, and then lastly, the employee's residence. And again, it varies jurisdiction by jurisdiction, so this is an analysis that varies based on the particular circumstances, but these are just some of the factors that are applied. Another thing to keep in mind with telecommuters is that don't just wait until your employee comes to you and asks, I need to take leave, because a lot of these laws, as you're going to hear later on, they require that you collect premiums from employees and remit those premiums and pay into it. So it's important to know early on if they're eligible for the leave, so that you could be fulfilling all those other obligations. And with that, I'll turn it over to Christina.
Great. Next slide. Thanks, Marlon. So turning to qualifying events, as you can see here, these first 4 reasons related to bonding with the child, so birth, whether it be birth, adoption, foster care placement, as well as caring for a family member with a serious health condition, these are all qualifying events under all of the mandatory PFML laws, so those 12 states plus DC. Then when you go to the next one, an employee's own serious health condition, as Josh mentioned, there's going to be some variation here throughout the different states. And that's going to depend on whether it's a paid family leave law, PFL law, or a paid family medical leave law, with an emphasis on the medical there. And so as Josh mentioned earlier, you'll see missing from this list of states that allow for an employee to take leave for their own serious health condition, that a lot of the early adopters of California, Rhode Island, New York, New Jersey, their PFL laws do not cover this employees on serious health condition, because that's separate under their state disability law. You'll also see qualifying military exigency for a number of the laws, and some laws with military caregiver leave kind of mirroring the FMLA. But then things get a little broader. And so as these laws, as more states are kind of expanding and developing these laws, we're seeing some new reasons. So for example, bone marrow donation. You'll see that Connecticut here codified this into its paid leave law. Now, leave for bone marrow and organ donation, there's a number of unpaid leave laws that have developed throughout a number of states that provide job protection, at least. Connecticut, as I just mentioned, has added it to their paid leave law. It should be noted also, though, that there are some paid family leave laws that have included organ donation into their definition of a serious health condition. So for example, under the New York paid family leave law, an employee can take leave to care for a covered family member who has surgery related to organ or tissue donation because it's included in the definition of serious health condition. So that's just a reminder that, you know, when you see these different reasons for leave, that it can be really helpful to take a closer look at these definitions to understand what is exactly covered. Another example, as Josh mentioned, is family in Minnesota, family care leave also covers caring for a family member who's a member of the military. So another example there. Safe time is another one where we're seeing more states add this in. You know, as Josh mentioned, this is very common in a lot of the paid sick leave laws. A lot of them are now referred to as paid sick leave and safe time laws. You'll also see that a lot of states have this as an unpaid leave as well, now being added to these paid leave laws. So one thing to note, even within this kind of umbrella of safe time, there's some variation. So a number of the states, so for example, Colorado safe time covers not only individuals who are victims of domestic violence, but also stalking and sexual assault. You know, some of these laws apply to the employee or the employee's family member who's a victim of domestic violence. So another variation there. And I would say a number of common covered absences could be things like seeking civil protective orders, obtaining medical care or mental health counseling, addressing the physiological or psychological results of domestic violence, relocating, seeking legal assistance. So again, each of these states is going to have, you know, some specifics that you're going to want to drill down on when determining whether an employee is eligible and what they're eligible to take. Bereavement leave this year was added to Washington's law. And actually, pretty interestingly, Oregon expressly excludes bereavement leave from its PFML law. And so the reason for that is most likely that Oregon's unpaid state FMLA law provides 2 weeks of unpaid bereavement leave. And so when developing their paid family medical leave law, they specifically decided to carve that out and say bereavement leave does not apply. Another new type of leave here is prenatal care, which is paid leave that an eligible individual who is pregnant may take for a prenatal medical care. And so this definition of prenatal medical care is broader than just a complication, which you commonly see with pregnancy-related leaves, or leave to recover from childbirth. It also includes routine and specialty appointments, exams, ultrasounds. So this is new in that, you know, a lot of the current laws allow for employees to take leave related to their pregnancy because it's related to the serious health condition. But it doesn't cover routine appointments like ultrasounds, unless you're in DC and Minnesota now. Then finally in New Jersey and New York, we have qualifying events that were added as a result of COVID-19. So New Jersey is a little broader and covers quarantine needs related to a state of emergency or based on an order from a public health authority, whereas New York has added a COVID-19 related absence to its definition of family leave, which would essentially cover absences where there's an order from a public health authority or mandatory quarantine. It also provides care for a minor dependent child of the employee who's subject to a mandatory precautionary order of quarantine or isolation that's issued by a state Department of Health board. So next slide. All right, so covered family members. So it's clear from this chart here that there's actually a lot of overlap between who's covered as a covered family member. You'll see that child, parent, and spouse, the covered family members that we're all familiar with under the FMLA, all of the mandatory laws cover those. It should also be noted that Delaware has followed the FMLA, and covered family members in Delaware are only child, parent, and spouse. Then, recently Maryland amended their law to add domestic partners. That's kind of interesting. And you'll see a number of states include domestic partners as part of covered family members. And then, we've seen in the past few years a significant expansion of who's covered. So noting that sibling, grandparent, and grandchild are covered by most of the laws. Next slide. And we're also seeing that, further expansion into the in-law category in some states. So you can see in Minnesota, Colorado, and Oregon, you have, kind of a broader category there. Child, spouse, and/or domestic partner. So you'll see in Oregon and Washington, it's child, spouse, and domestic partner. And then just noting that Minnesota appears to just cover the child, spouse. The most challenging expansion, though, is the addition of the individual related to the employee by blood or affinity. So this is pretty broad. So we've seen some additional guidance, though, on how employers can be thinking about this. So for example, I'm going to discuss Connecticut, which defines this category as any person with whom the worker has a significant personal bond that is like one of the family relationships listed in the statute, regardless of biology or legal relationship. So they say it's, situation specific, and it depends on the circumstances of the individuals involved. I find it pretty helpful to look at some of the examples they provided. So one of them being an unmarried significant other of the employee who maintains a familial spouse-like relationship. The other example that they've provided is an aunt or an uncle who relies on the worker for unpaid care and has the type of relationship typically seen between parents and children. So then we have, the next category is individuals who regularly reside in the employee's home or where there's a relationship that creates an expectation that the employee is going to care for that person. So that's in Washington. And then finally in Minnesota, pretty similar to Washington, but it's just a slight difference where it's an expectation or a reliance that the employee will care for the individual. And then this law specifically says it doesn't matter if the employee and the individual that needs care reside together. So overall, these kind of new category of relationships are more difficult for administrators to confirm than probably the standard family relationships, but each state has continued to come out with guidance to kind of help employers narrow that down. So definitely want to drill down on that when you're considering who is a covered family member for your employees. And all right, so we're going to go to the next slide. Take it away.
Thanks, Christina. So now that we know why an employee might be out on PFML leave, let's consider how long they might be out on this leave. First, let's think about the reasons for leave. So some laws will provide a single bucket of leave, meaning the same number of weeks regardless of the reason for the absence, while others will designate different lengths of benefits depending on the reason. So if they're out for family leave versus medical leave versus some of the other reasons that were talked about. The laws will also have a cumulative maximum length of benefits combined, and there can also be some variation in how the time period is measured. So are we talking about X number of weeks over a 12-month period, or are we talking about something else? So let's start by considering family leave. As an initial point of clarification, I do want to be clear that for purposes of today's presentation, when we say family leave, we are referring to absences both for bonding with a new child and also absences to care for a family member with a serious health condition. Now, some of the laws will lump those into a single family leave bucket. Other laws will split those into two separate categories, but again, for today's purposes, we are talking about both. And the length of available family leave benefits will vary anywhere from 6 weeks to 12 weeks, depending on the location. Let's revisit the concept of separate bonding with a new child leave versus caring for a family member with a serious health condition as two different reasons for use. To kind of see how this is play out differently under different laws. And specifically, we're going to take a real quick look at Delaware and Washington, D.C. So in Delaware, they break down the leave into two groups, and they have two different lengths. For bonding with a child, employees can take 12 weeks over a 12-month period. But for taking family leave for caring for a family member with a serious health condition, they can only take 6 weeks, and that's over a 24-month period. So that's sort of our different length of time as well. Now, on the other hand, Washington, D.C. also breaks these into 2 different categories, but both are currently set at 12 weeks. Moving to the next slide, we will talk a little bit about medical leave. And by medical leave, we are referring to an employee being absent due to their own serious health condition. The length of medical leave can vary. It can be as short as 6 weeks in a 24-month period in Delaware to as long as 52 weeks under the California State Disability Insurance Program. And just a little side note here, the California SDI and the other SDI programs that we have listed on this slide are technically separate from the PFML laws that we're discussing, or paid family leave laws that we were discussing. But we wanted to give these honorable mention simply because they do cover absences due to the employee's own serious health condition. In some locations, the length of medical leave available to an employee can actually be increased for certain scenarios. You will see those laws listed twice on this slide. And the circumstances when that happens is when there is some sort of incapacitation, limitation, or complication related to pregnancy or childbirth. So for example, you can see in Colorado, beginning in 2024, employees typically will have 12 weeks of PFML available for their own serious health condition. But if the employee experiences pregnancy or childbirth complications, that cap can increase to 16 weeks. Moving on to the next slide, in addition to the main categories of family and medical leave, many of the laws also provide paid leave for other reasons that are consistent with federal FMLA, such as military qualifying exigency or injured service member leave. But there are also some non-FMLA reasons on here, and I think it's important to note that many of these outlier reasons might have significantly shorter lengths of benefits available. So for example, in Connecticut, safe leave is available for only 12 days per year, and this seems to be more closely aligned with the thinking of safe leave as a shorter term absence, something similar to what we would see covered under a paid sick and safe time law, as opposed to an extended family and medical leave. Likewise, in Washington State, bereavement leave is available for 7 calendar days following the death of a family member, and that seems to generally align with the length of time we would typically see under an employer-provided, voluntary bereavement leave benefit. I would like to point out just a couple of types of leaves that we did not include on this slide for Maryland and Minnesota. Both of those laws are new. They're not yet in effect, and some of these details are still being ironed out. In Maryland, there is a military caregiver leave. Typically military caregiver leave in other locations is usually 26 weeks. As of right now, it's looking like it's going to be limited to 12 weeks in Maryland and then also in Minnesota. And staying with the Minnesota location, there is leave available for prenatal care, incapacity due to pregnancy or recovery from childbirth and that sort of thing. It's unclear whether that leave will be limited to 12 weeks, similar to the other types of leave. And then moving to the next slide, talking about the combined total length of benefits. Let's think about how this all comes together now that we've talked about the different types of leave. The total combined cumulative amount of leave available can vary anywhere from 12 weeks to 52 weeks. I just want to point out a few things on this slide. We've listed New Jersey at 38 weeks. That is because the short-term disability insurance and PFL may or may not run concurrently. It's not entirely clear, but the most conservative reading would be that you could stack those 2 leaves, so 12 weeks plus 26. On the other hand, New York and Rhode Island, it is clear that you cannot stack, and the laws, they offset. And then there are a couple of locations, again, that are listed multiple times. Again, that's due to the pregnancy the pregnancy complications. And finally, Washington, D.C. Shows up in both the 12 weeks and the 24 weeks row. That is because D.C. provides 2 weeks of leave for prenatal care. It's not entirely clear if you can stack that with 12 weeks of medical leave. So now that we have a handle on how much leave employees are entitled to, let's move on to the next slide and consider when the employee is ready to return to work and what happens. So job protection is a very important point with these laws. If it's handled incorrectly, you could end up terminating someone in violation of one of these laws. And we will split out job protection into 3 categories. We have the laws that provide job protection without conditions, and these laws provide absolute job protection to all employees who take PFML leave, no conditions that they have to meet in order to have the job protection. Next category, we have job protection with conditions that must be satisfied. And these laws will provide job protection to employees, but only if the employees meet certain conditions. Typically, they have to be employed for a certain length of time or meet a certain number of hours worked. And then finally, there are some laws that do not provide job protection at all. But I do want to just caution you with those that just because there's no explicit job protection under the PFML or PFL law does not necessarily mean that you can just freely terminate the employee. There's often going to be other laws like FMLA or a state FML program that will provide job protection to those employees. So finally, I do want to spend just a minute talking about who administers the program on the next slide. There are 2 different ways. There's either programs that are administered by the state only. There are only 2 states that operate that way, or sorry, it's 1 state plus DC, that's Rhode Island and DC. All employers have to use the state fund. Employees must apply to the state for benefits. The other way is the option to have a private plan, also known as an equivalent plan. And under those locations, employers typically have to meet certain criteria to make an equivalent plan and apply with the state to be approved to operate that way. So I will now transition back over to Christina to talk about funding.
Great. So who pays for these benefits? Initially, these laws relied on the employee to fund these programs. You'll see again, those older PFL laws are in this category with the exception of Connecticut. That is one of the newer laws that is only funded by employees. Employer funded, DC is the only location where it's fully funded by employers, and that's because of basically the DC law required that it basically had the DC law had a limit in terms of allowing contributions to come from employees. And then the remaining states, it's a split. I would say the newer states like Colorado and Delaware are more straight 50-50. Some of these laws have exceptions or a smaller contribution amount for small businesses. In some states, employers can pay for the whole amount. Some states like Connecticut don't allow that. So here's the breakdown, and then we're going to go to the next slide.
Thanks, Christina. So now we're going to talk about the amount of pay. So there are 3 slides with lots of information on the amount of benefit payments, which you could reference later. I'm not going to go through all of it, but I just want to tell you some of the big takeaways. One of the biggest takeaways is that each jurisdiction varies greatly in how much benefits they provide to employees, so the amount of pay in terms of percentage and amount varies greatly. We have California on the lower end percentage-wise at 60 to 70% of the employee's average weekly wage, depending on the employee's income. Whereas on the other end of it, we have Oregon, which replaces wages of up to 100% of the employee's average weekly wages, up to 65% of the state's average weekly wage. If an employee makes more than that, then that additional amount of money that the employee makes is replaced at 50% of the employee's average weekly wage. Now, this setup, this sort of gradual percentage based on income setup is common in a number of jurisdictions, including Connecticut and Colorado, DC, and Washington. And the reason for that is it's meant to ensure that low wage earners receive wage replacement for all or most of their wages while they are on leave. The maximum weekly payments also vary greatly. We have at the lower end Connecticut as of June 1st, 2023, and Delaware beginning in 2026, which are both at $900 maximum per week. Whereas on the higher end, we have Washington at $1,429 and California at $1,620. So interestingly, although California has the lowest percentage, it has the highest maximum weekly cap. The biggest takeaway from this is that these amounts change frequently. In many jurisdictions, they change every year. So just be sure to check for updates regularly. And with that, we'll go to the next slide, and I'll pass it up to Renata. Next slide. And one more. Thank you.
Thank you, Marlon. So very quickly, I just want to touch on notice and posting. Those two terms are often used interchangeably, but they do mean two different things. And posting, of course, means displaying a poster in a conspicuous location in your workplace. Almost all of the PFML laws require employers to do this. Notice, on the other hand, means providing a written notice directly to the individual employees. And I think most employers are pretty familiar with the concept of handing a notice to the new hire during the onboarding process. But we did want to point out to you all that many of the PFML laws actually have additional individual notice requirements where you have to give this at other times, such as annually or when the employee actually needs PFML leave. And at least one law, Massachusetts, requires employers to have employees acknowledge receipt of the notice in writing. So with that, I'm going to pause for just a moment to read the CLE code. Our CLE code for today's presentation is SS as in Seyfarth Shaw 3741. Again, that is SS for Seyfarth Shaw 3741. Now I will hand the mic over to Josh for some final thoughts.
Perfect. Thanks so much, Renata and Marlon and Christina. As all of you can see, a ton of information comparing these 12 laws to these 12 state laws plus DC across those 10 substantive topics. As you'll see on the next slide, that is about half of what these PFML laws cover. And again, the CLE code, just for folks who didn't get a chance to jot it down, SS is in Seyfarth Shaw 3741. As far as other topics that are out there, you can see on this slide, there's a whole host of additional criteria substantively that the programs will generally dictate based on their terms and conditions that employers will need to follow for their employees, that they'll need to be aware of when employees are taking time off, or when they're going the private plan route that they'll need to bake into, in many cases, those private plan considerations and application processes. Those include things like waiting periods, intermittent leave, employee notice and documentation, what the claim process looks like, the continuation of benefits and medical healthcare related benefits, remitting and reporting obligations at the end of each quarter, record keeping, private plan requirements, which are hugely important for employers that have multi-state and nationwide operations, anti-retaliation, confidentiality components, as well as two other very big considerations from our perspective: coordination of benefits with company programs and coordination with other laws. Next slide, please. As far as what's coming next, right, looking into a crystal ball, and while we can make no guarantees, there are some locations, Maine, New Mexico, Michigan, that look poised, probable that in the next year or two could end up having a paid family medical leave program get enacted. Both Maine and New Mexico had studies, legislatively commissioned studies, take place over the last couple of years, studying the feasibility of adopting a PFML program in those locations. Maine, in particular, earlier this year, back in March, announced that the results of that study came out favorably for a PFML program. There was a bill that was introduced, although it's unlikely to get passed this session, setting up 2024 to be a year where we expect Maine to join this growing list. Some other states to pay attention to, we mentioned earlier, places like Virginia, New Hampshire, Vermont, with these not quite mandatory PFML programs, but some other activity going on there. And South Dakota is actually making a potential push to join Vermont and New Hampshire with a voluntary program. Next slide, please. So then you have some resources to help keep you sort of level-headed and make sense of this patchwork as it continues to evolve and gain more layers of complexity. Those are things like Seyfarth's Paid Family Leave Survey. We maintain a comprehensive survey breaking down each of these laws across all the relevant topics. You can email us at paidleave@seyfarth.com for more information. We also have a paid leave mailing list that you can sign up for, and you'll get all of our legal updates, blog posts, client alert series, anything that's sort of out there, including webinar invites and podcast episodes that involve paid family medical leave and paid family leave. So definitely worth signing up. It's free to sign up and get all those hits. Next slide, please. We also then have our webinar series. This webinar series, which is part 8, you can see the notes on parts 1 through 7 On the slide here in front of you, we have available copies of the decks and recordings for parts 1 to 7. So if you are interested in those, please reach out. We also have a separate paid sick leave webinar series, as I mentioned earlier in the presentation. We have our next segment for that webinar series coming up on Tuesday, June 20th, so it's coming Tuesday. And finally, we have a dedicated Take It or Leave It podcast dedicated specifically to workplace leaves, absence management, and accommodations. We're over 20 episodes.
Welcome to Seyfarth Show.
Plenty of great guests for those episodes, and we hope you can take a listen if you haven't already. So with that, we're going to go to our final slide with questions. We did have a few questions come in, and even though we are at the top of the hour, if folks are willing to stay with us for a couple of minutes, we're happy to go through just a few of those as they've come in here. So I'll take one of them, which I think is a really good question, really important question for folks, which is, do any of these PFL laws not permit the PFL leave to run concurrently with a leave program that has job protection, like the FMLA, or a state equivalent, like the unpaid FML law in New Jersey or California, what have you? The answer is technically no, but it's complicated because while these benefits can run concurrently with one another, it's important to remember a few things. A, the employee has to be eligible for both sets of benefits. That particularly impacts new hires, part-time workers, seasonal workers who might trigger eligibility under the lower eligibility threshold for a PFL or PFML law, but not under the state unpaid FML or the federal FMLA. Similarly, there are plenty of examples where these PFL laws, right? Christina spoke about the nuances with the covered reasons and covered family members and how widespread and broad these PFL laws have taken those topics. Compare that to the FMLA, the federal FMLA that is, or some of these unpaid FML laws, and you have a lot of areas where even though the worker might be eligible for both sets of benefits, the covered reasons might not overlap. So the benefits could still stack if an employee, for example, takes time off for safe time under a PFML law, uses up a good chunk of their benefits, and then has a covered reason like bonding that would trigger the unpaid FML or the FMLA, right? And then I think sort of finally to round out this point, there is sort of a level again of understanding of how these laws and what type of protections they bring to the table and what their standards are for coordination of benefits when you're thinking about company provided leave and how that fits in to the potential concurrent running of those time off benefits. So good question. Thank you very much for sending that one in. We had another good question come through asking if an employee lives in one state but works in another, which state controls the leave? And Marlon, I know you covered this a little bit earlier on in terms of teleworkers and remote hybrid workers and the like. From my perspective, I think it sort of comes down to having to look at what the state says on that point. If they have a standard, right, on mobile workers, what those standards kind of look like and how they speak to one another. And anything else you want to add on that point, Marlon?
Yeah, and what the work arrangement is, how often are they working from home, how often are they working from the office, and again, looking at the particular jurisdiction.
Perfect. Thank you. Thanks. Yeah, it's a really good question. As Marlon said, it's a topic that, especially in the last 3 years and 3 months, give or take, since COVID started, teleworking, hybrid remote working has become sort of part of the fabric for a number of companies, at least for certain groups of their employees. So these considerations become a really big deal. And the mobility of these benefits, right, how they go from one jurisdiction to another when the worker is triggering potentially multiple of those eligibility criteria, is something that a lot of these laws might not speak to as clearly as we'd like. Some of them do a decent job at it, but it is something that when these laws were drafted, I don't think they had this remote hybrid worker concept in mind. So a really important question there. And we'll have time for maybe just one more. There's a question about Minnesota way back from the beginning of the presentation today. Someone asked, what if an employer in Minnesota already provides for paid parental leave, medical leave? Does that mean they still have to pay into the state of Minnesota's, right, that forthcoming PFML program? So the short answer is, unfortunately, yes. right? And this is where this topic gets so complicated and convoluted for companies. A lot of companies that have these generous company provided offerings, short-term disability, paid parental leave, caregiver leave for family members who have a serious health condition at the company's own generosity, then have one of these laws come into place. And the company either A, needs to apply for a private plan, which many times the baseline STD or PPL, paid parental leave or short-term disability program that they have won't hit all those boxes, won't check all those boxes that the state, requires for an approval of a private plan, because the private plan approval requirement very often is some level of equivalency with the state program and its requirements. So if you have a paid parental leave policy that the company offers, it's 6 weeks, 8 weeks, 12 weeks, but the state requires more than that, or 12 weeks, 14 weeks of bonding leave, that would be something where the employer program wouldn't meet the criteria, even if the amount of weeks lined up between the parental leave and the state program on bonding. If the company doesn't also offer any of those additional covered absences, like family member serious health condition, like military exigency, through the company benefit, it's unlikely that they're going to get approval for a private plan unless they raise the bar and provide those benefits through the company's private offerings. So unfortunately, the employer either has to go that private plan route, or they need to look at carefully what the states say in terms of coordination of benefits and how company provided parental leave, short-term disability, PTO, vacation, sick, and so forth run with those state benefits, and understand whether they can be run concurrently, what conditions might exist in order to have them run concurrently, how the pay might need to be offset, and so forth. So it's a really messy setup, and it's a really good question, specifically because either our next webinar of this webinar series or 2 cycles from now, depending on how things shape up with Oregon coming online in a few months, we're going to be covering these topics in a lot more detail. So stay tuned on the coordination of benefits and private plan piece. Okay, with that, go to our last slide. Thank you so much, everyone, for joining us. Our contact information is here. We look forward to seeing you at our next segment of our webinar series.